Thanks, Chelsea, and thanks everyone for coming. And as Chelsea said, just jump in with questions along the way because I talk quite quickly and I'll probably cover a lot of material. So just interrupt me whenever you want to, and I'm happy to answer anything as we go. So there's our normal disclaimer. If you want specific advice, just contact me afterwards. So normally when I do these presentations, I spend a lot of time on testamentary trusts, and that's probably why a lot of you are here tonight to hear more about them. They're quite a common strategy that we recommend as part of a more complex estate plan. But what tends to happen is we spend so much time on that component of it that we forget about the other, or they get mentioned in passing, the other equally as important components to an estate plan. So I thought we'd do a pineapple upside down cake today and talk about those other elements first, and then finish on testamentary trusts and talk about how we can tailor them as part of our estate plans. And then you can ask all the questions that you like. So we'll start off with enduring powers of attorney, talk a bit about superannuation, trusts. A lot of you will have family trusts as part of your structure. Then we'll talk about testamentary trusts and wills and tailoring those testamentary trusts for your particular circumstances, which is really important because one size does not fit all. But why are we even doing this? Well, we're trying to protect ourselves from the triple trap. And I always ask this question at the beginning, and hopefully those of you who've been to my seminars before will get the answer right this time. So how many people in the room have an estate plan in place? Oh, I know Dean has, because I did his a month ago. So, yeah. So, well, actually you all do. So, and that's the first trap that we fall into. Everybody does have an estate plan. It just is probably not the one that you want. Because if you don't have a will in place, you don't have powers of attorney in place, you haven't made succession arrangements in relation to your structures, something will still happen to those assets, and someone will still be appointed to deal with those assets. But it will be up to the default mechanisms that we have in law. So the intestacy provisions, the terms that are in your trust deeds, someone applying to VCAT to be appointed as your administrator or your guardian. So there will be a default mechanism in place, but it quite likely won't achieve the outcome that you want. So that's the first trap that we're trying to avoid. The second trap is not understanding that estate planning is much more than just a will, which is why I'm going to start with those other elements first. It does involve looking at who's going to make decisions for you if you lose capacity. It does involve looking at superannuation, and it does involve looking at other structures that you might have, like family trusts or companies, and how whatever succession mechanisms are in place if something happens to you. So that's the second trap. The third trap is don't become a war story. That's what they're the ones that we hear about, and we don't want any Aintree group clients becoming war stories. So let's deal with the estate planning while we still can. Throughout tonight, I'll probably refer to my own family a little bit in terms of illustrating examples. So I've got 4 beautiful children. 2 of them you may have even spoken with because Ollie and Laura both work here. And I've also got a partner who's in the room, but I won't point him out in case he gets embarrassed. But I will use various examples as we go through. So let's talk about enduring powers of attorney. So this is planning for incapacity. So if you are still alive, because if you die, any enduring powers of attorney are automatically revoked and your will kicks in. But we need to put a plan in place to appoint people to make decisions for us if we can't make them for ourselves. So that's what we're doing when we're putting in place enduring powers of attorney. The problem is in Australia, every state has different documents, different rules, different requirements, even different requirements for witnessing, different requirements as to how many people you can appoint. Some states you have to register your power of attorney with the Land Titles Office before you can deal with any land. So it's important to look at what documents we actually need. Because we operate in all jurisdictions, so there will be clients that we have interstate that we need to do documents for. And if you own assets in some other states like New South Wales, Queensland, Western Australia, it's a good idea to at least explore whether you should have separate powers of attorney in each of those states, because it's a much more seamless process to be able to deal with land in particular if you have an enduring power of attorney that accords with the rules of that particular state. So it's important to look at what documents we need. The most common ones, and the ones we have in Victoria, so they're most applicable to all of you, are enduring powers of attorney for financial matters and personal matters. So financial, making decisions, paying bills, signing documents, dealing with assets, and personal decisions like where you live is probably the main one. And then we have a separate document to appoint a medical treatment decision maker. And you've probably also heard of an advanced care directive. I've often heard them called recently a living will. That seems to be a term that people are using at the moment to refer to advanced care directives. They're much less common here in Victoria because our witnessing requirements are tougher. We have to have a doctor sign off on it, whereas in other states you can just, you can even do it online and just have a document that directs your decision makers as to what you want to do in terms of turning off life support or those sorts of medical decisions.
Sorry, we have a very robust IT security system that logs us out if it's been inactive for too long.
Maybe I should touch it a little bit more. Yes, Sandra.
In the meantime, so with the medical power of attorney, does that also include, like, say for example, you want a long-term plan from whilst you're still fine, if you were to reach certain milestones, if you wanted to do end of life?
Yeah, well,
in that, or is that a separate document?
Well, one thing that nobody can do for you is voluntary assisted dying. So that's, your attorney can't do that, your medical treatment decision maker can't do that. But you can provide directions to your medical treatment decision maker about those sorts of things in terms of, palliative care and not keeping you on life support, those sort of end of life wishes.
And that has to be documented.
That's normally in the advanced care directive, which is signed off on by a doctor. So the sorts of considerations that we would consider, that wasn't very good, Peter, you'll pick me up on that one, is who to appoint. That's probably the key thing, because you want to appoint somebody that you trust to carry out your wishes, to make the right decisions for you. But it's also important to have backup people in place, because you don't know if that person is going to be in a position to be able to act. Quite commonly people will appoint, say, their spouse and then adult children to fill those roles. But you need to think those things through. Then also consider how they should act. So should they make decisions together jointly? They all have to agree. That provides a certain level of accountability, but it can also hold up decision making, because it's quite problematic to get 4 children, say, to sign off on every single document or bank transaction or something along those lines. You might also want to have a professional person in there as a circuit breaker if your kids don't agree, for example, and to provide that level of independence and accountability into the documents. So, for example, if you've got 2 children, you might appoint 2 children plus someone else, and to act by majority, so 2 out of 3 can make the decision. If your 2 kids agree, great, they'll always trump the professional advisor. But if they have a disagreement about something, or one is sort of looking after their own interests rather than the greater good, then the professional person can sort of step in and break that deadlock. Think about when it's to start. So you can just have powers of attorney commence immediately. And certainly for financial powers of attorney, we often suggest that, because it's very convenient. It means that people can start acting straight away. So even if you're overseas or something like that, your attorney can do things for you in Australia, even if you still have that decision-making capacity. You'll always be able to trump the decisions of your attorney if you have decision-making capacity. The other common trigger is if you lose capacity, but that does have to be signed off on by a medical practitioner. And as we get older, there's a bit of a grey area there where we might not have lost decision-making capacity, but we're not really up to making all our own financial decisions, say, or, you know, attending to all our paying our bills or making those day-to-day sorts of decisions, and it would be good to have some help. So you might want to have it commence when you authorise your attorney in writing, immediately upon signing, or once you lose capacity, or some other trigger event, and we can build that in. So have a think about what powers to give, and the big one here is to think about superannuation, because that's all the cases are quite grey on that area as well, in that they look at whether the attorney had the power to actually make a decision for the member if they've lost capacity. That might be things like withdrawing super out of the account, which you might want your attorney to be able to do. A lot of one of the estate planning strategies that people employ is if they've got adult children who would have to pay tax on the superannuation that they receive, they might want to withdraw it from super if they've got a terminal illness or, you know, a close to death, so that it forms part of their estate rather than it being received via super. But if your children need to do that as your attorneys, they need to have the power to be able to do that, or to update any nominations that could lapse, especially if it's with an industry or a retail fund that might lapse after 3 years. If you want your attorney to be able to do those things, you need to specifically authorise it, or we recommend you specifically authorise it so that it's not the subject of debate, and be really clear about what they can and can't do. So if you don't want them to be able to change who gets your super, say that. Say, you know, they can't change the beneficiary of the nomination. So there's lots of options that we need to consider, and it's not just a straightforward form that gets filled out anymore, because there are all these options along the way that are really important to work out what's right for you and your particular circumstances. I have put a note on the end there as well about corporate powers of attorney. There's a lot of people, a lot of our clients run businesses, they might be they're sole directors of a lot of companies, and the process, sure, you can have an enduring power of attorney in place that appoints Joe to be your attorney if you lose capacity. But the way it works with a company that you're a director of, your attorney doesn't just step into the shoes of the director and start making decisions. What the technical process for that is that the attorney takes control of the shares in the company, then appoints a new director to then act. So it's a lot more seamless if we put in place a corporate power of attorney in that situation, where a sole director can say, if I lose capacity, or even if I die and my executors are fiddling around with the estate and haven't quite gone through the process of probate and distributing the estate and working out what's happening with the company, during that period, or any other period, even if I'm overseas or whatever, I appoint X to step into my shoes as director, or not even step into your shoes as director, step into the decision-making, to have the decision-making capacity on behalf of the company. So it's actually the company appointing the person to make decisions for the company and sign off on documents for the company. So that's another document to consider as part of that power of attorney process. Does anyone have any questions about any of that? No? Mike? Sure.
So the power of attorney ceases on the death of someone, but the corporate power of attorney doesn't.
No, not necessarily, because it's actually the company that's making the appointment. So the company will decide, through the director obviously, when that power of attorney will be in place. And normally it will say, if I authorise the attorney in writing, then they can start making decisions. If the director loses capacity, or all the directors lose capacity, or all the directors die, and it will tend to operate until it's either revoked or until the estate has been administered, for example. And then once the estate's administered and other people have been appointed, which may well be that same person, that's when it will cease. But the company gets to decide when it starts to operate and when it stops operating. and that will be the director on the behalf of the company that's making that decision. So, yes.
I was just going to ask, how do you define losing capacity?
Yeah, so that's up to a medical practitioner to certify. If you don't put parameters on it, then it's just when a doctor says you've lost decision-making capacity, so the ability to make your own decisions. You can build extra requirements into that. So sometimes people will say, I want 2 doctors to sign off that I've lost decision-making capacity. Or sometimes people will say either decision-making capacity or I'm not capable of looking after my day-to-day affairs or something like that. It can be a bit wishy-washy though. And there is that grey area where haven't quite lost capacity in a medical sense, but I'm not really up to making my own decisions. And so that's why, particularly with elderly clients, we'll normally recommend have it commence immediately for financial decisions and personal decisions, so long as it's someone that you trust, because then it just makes it easier for the attorney to be able to help you when you need it. A lot of younger people won't like the feeling of losing control of their own decision making, even though they don't lose control, they can still trump their attorney. But they will often want to only have it kick in if they've actually lost capacity. So you get to choose, basically.
Does it make any difference whether or not the person you appoint while you are still alive is a beneficiary once you die?
Good question.
It does have an executive beneficiary once you're dead.
Yeah, well, most executors, though, that we appoint when their family members are also beneficiaries. So it makes a difference in a couple of respects. If there's an inherent conflict of interest there, if an attorney is also a beneficiary, say, or even a child or a spouse, there's an inherent conflict of interest in a lot of the decision making. If you own a house with your spouse, which most people do, you own a house with your spouse, if you're deciding whether to sell that house on behalf of both of you, so on behalf of yourself and also on behalf of your spouse who's lost capacity, there's an inherent conflict there because you've got a vested interest in the decision that's being made. So we normally allow those conflicts of interest when it's a family member like that we want to be able to make decisions freely without having to without being prevented from doing that or without having to get approval from VCAT for making a decision where there's that inherent conflict of interest there. There are complicated rules about tracing through. If an attorney does something that then means that a beneficiary doesn't inherit under a will, you can trace through the proceeds. It's quite complex. So yes, there are inherent conflicts there that we need to consider and allow if we want to, or if we're not going to allow them, make sure that they work. Sometimes you won't want them to be able to make a decision if there is a conflict, and they might have to leave it to the other attorneys, for example, if there are multiple. Does that answer your question? So, yes.
Is it better to have, so for example, I've got 2 kids, 50-50 LPR?
Well, that leads us to the next topic on dealing with super. Okay, who can benefit? You must have seen my slides come off the printer, Sue. So who can benefit? Well, you can only leave your super to a superannuation dependent. And it's confusing because there are 2 different definitions in the different legislation. So there are superannuation dependents under the SIS Act, and there are tax dependents or death benefit dependents. Superannuation dependents are the people you can leave your super to. You can't leave it to anybody else. Tax dependents is a definition as to how that super is treated when it's received by certain people. So they're different definitions and it's very confusing. The one we're going to focus on is the superannuation dependent because that's exactly the question you're asking. You can leave your super to your spouse. That includes a de facto spouse, and I'll explain why I've asterisked that. You can leave it to children of any age, and that in some circumstances includes stepchildren, and there's a reason why I put a star against that as well. someone that you're in an interdependency relationship with, which is basically a close personal relationship where there's some level of dependency involved. It's quite difficult to prove when it's not already a spouse. It's even difficult to prove for children and for parents. So we don't rely on that very often. And then your legal personal representative or your estate, your executor. They're the only people you can leave your super to. And so when people will fill out the form for their super with their industry or retail fund, and they'll leave it to their siblings equally, or they'll leave it to their parents, that's actually technically invalid. So if they want those people to benefit, they actually need to leave it to their estate and then have that provided for in their will. And that's a really common misconception. Yes.
If you're partnered up and you have no children,
Mm-hmm.
and you left whatever superannuation you had to your partner, and you both got killed in the same plane accident,
Mm-hmm.
whatever.
Okay, well, if there's not one of those, it would actually be up to the trustee, which we'll talk about, but the trustee could only leave it to those people, and if there are none of those people left, it would go to the estate. And if they don't have a will in place, it would be the laws of intestacy. And if it's gone to your partner and your so your super goes effectively into, well, it wouldn't in that situation because it would go straight to your own estate. But with jointly owned assets, that is a problem when it can go to your partner and then go via the laws of intestacy to that family instead of your own family. So yeah, that's another reason why we should have wills in place.
Does it matter? They look at who actually died first in that scenario? Like, is there something like, I thought there was a case on this that they...
Yeah, so yes. So so the law provides that you basically have to survive someone by 30 days to inherit. But with jointly owned assets, so your jointly owned home, your jointly owned bank accounts, if you die together, then it's whoever is younger is presumed to survive the older person. So if they don't know who actually died first, they'll say
Like
the younger person, they'll say the younger person survived. So say with my partner, which this is made up, say we owned a house together. We both got our own children separately, but we owned it jointly together. And we both died in a car accident. I'm younger. So I would be presumed to have survived. I would be presumed to have survived. And so I would inherit that property, that jointly owned property, and the whole of that jointly owned property would form part of my estate and would either be distributed according to my will, or if I didn't have a will, according to the laws of intestacy, and would go to my children. So it is really important that we account for these situations. So in that sort of blended family scenario, I would always say own it as tenants in common if you're going to own it together, because you have a distinct separate share that you can deal with, even if you provide for a right of residency for the other or whatever. So yeah, that's getting off track, but I hope that answers your question because it is a really important thing. And something that people don't realise when they own an asset jointly, that it automatically goes to the other joint owner. You can't leave it to anyone in your will anyway. So any jointly owned assets that you have will automatically go to the survivor. Okay? Answering your question, Sue, about whether you should leave it directly, your super directly to your children or to the estate, depends on a number of factors. If you want it to go, if they're adults, if you want it to flow into a testamentary trust, which we'll talk about in a minute, and then fund that, then you'd leave it to your estate. If you want to keep it simple, keep it outside of a trust structure and just want it to go to them directly, then you could leave it to them directly 50-50. The risk of that is if something happens to one of the children, it won't automatically go to their children. Say it'll go back into that pool of super that the trustee of the superannuation fund will probably leave to the surviving child. So one of your children's children might miss out. And I know that's an unlikely situation, but generally I would say leave it to your estate. If you've got adult children, leave it to your estate, then have your will govern it.
If one of them passed away and they had children?
Well, quite often you can't. With retail or industry funds, most funds, you can't actually do cascading nominations where you have different scenarios and say, if this happens, then I want it to go here. If that happens, I want it to go there. And remember that you can't leave it to your grandchildren anyway. It has to go into the estate because they're not a superannuation dependent.
You put all of those cascading things into the will into the estate. So if it went
Yes.
to the estate, then it falls
Correct. And you could leave it to anyone in your estate. You could leave it to a friend or another relative.
Is there a way of getting the super fund to, like every 3 years, you seem to have to nominate with them again, what do you want to happen? Or they just default to
Yeah.
a lot of it themselves, I think. But you want it in your legal personal representative. Is there a way of...
You can nominate your legal personal representative, and they will. Most funds will say if 3 years has elapsed and it's no longer a binding nomination, it becomes non-binding. So they might be guided by it, but they won't be bound by it. And they'll normally have their own rules as to who they will distribute to. It will normally be a spouse, but they'll also ask for who any other dependents are. So if there are young children, they'll consider all of that. It's much better to have a binding death benefit nomination in place because regardless, even if at the end of the day there is only one person that will end up benefiting, if there's no nomination in place, you need to jump through a lot more hoops. You need to provide stat decks and evidence that there's no other person that could be entitled.
So you just keep doing it every 3 years?
Yes. So, and that's, I think that's on my next slide. No? It's in a couple of slides, but they're the, well, yes, if it's lapsing, you do need to diarise it to remember every 3 years. Self-managed super funds, a lot more flexibility. You can tailor your binding death benefit nomination. You can have it cascading. You can specify the form of payment. So whether it's a lump sum, whether it's a death benefit pension, whether you leave it up to your executor if it goes into the estate, if you leave it up to the trustee, and we'll talk about control of the trustee. So there's a lot more flexibility with self-managed super funds, but even if you've got an industry or a retail fund, just make sure that there's a binding death benefit nomination in place. And that's the reason I flagged de facto spouses, because even though de facto spouses are defined as spouses, so if you're in a genuine domestic relationship, with the super funds, you still have to prove that they're your partner. The partner still has to prove that they're the partner. So I had a client recently that had been with his partner for 24 years, living in the same house for 24 years, but because she died suddenly, didn't have a binding death benefit nomination in place. And the hoops we had to jump through in preparing statutory declarations, getting sign off from the children that they were okay with it going in this way, to distribute the superannuation in a particular way and prove that he was the partner, could have just been avoided by having a binding death benefit nomination in place. So it is important to have that certainty. We won't go through all the tax implications of it, but there is a slide in here which goes through that. Whoops, there. So you can look at that later and you can contact Shane if you want more explanation. Basically, if you've got adult, financially independent children, they will pay superannuation death benefits tax on a component of your super, the taxable component of your super. And if you want to know what that means, that's sort of a financial planning issue and an issue for Shane as to what proportions of your member balance are taxable or tax-free. But there's no way of avoiding that unless you withdraw it before you die, which is what we talked about before. And so it's really that, but that should factor into your decision making when you're deciding who to leave your super to. A lot of people will say, oh, instead of leaving my super to my spouse, I'll leave it to my kids, you know, because it'd be nice for them to get something directly when I die. fine, except they will pay, if they're financially independent children, they'll pay superannuation death benefits tax on that super, whereas a spouse won't. A spouse, it's always tax-free. So you might want to give your super to your spouse and provide for your children in a different way if you want to do that. Likewise, you know, someone that's, if you've got a child that's financially dependent on you, so say, for example, they're disabled or they, you know, have various issues that have meant, you know, they're living with you, you're paying for their general maintenance and so forth, you might want to benefit them under your will via super, or allow the flexibility for them to benefit via super, because they could receive that tax-free and then still have it equal between your kids, but have your kids receive other assets. So all of those things should factor into your decision making.
Can I just jump one quick comment? There are some tax strategies to reduce that death benefits tax. So you can't potentially eliminate it, but there are strategies, and if you need more information on that, you can talk to us about it. So
yeah,
but it's something that people,
so like recontribution
strategies and so on.
So it is important to consider what those implications might be. So binding death benefit nominations are really key to all of this. And as I said, with self-managed super funds, there's a lot of flexibility and tailoring that we can do around that. It is important that they are technically valid. So there's, you know, I always refer to this case because it's a lawyer, and I think, you know, it's a lawyer and this is what the lawyer did. So a lawyer had a self-managed super fund, and he was in a second relationship with Mrs. Munro. He got a template binding death benefit nomination from his advisor. I think it was a financial advisor, not an accountant, which he filled out. Signed it, it was all signed properly and everything, but he left his super to the trustee of his estate. Now you would think that, because his intention was for the super to go into his estate and then go to his kids from his first marriage, you would think that was pretty straightforward. But Mrs. Munro number 2 challenged that, because she took control of the trustee of the self-managed super fund once he died. And she said, no, I'm going to disregard this binding death benefit nomination because it's not technically valid. I'm in control of the trustee. I'm going to distribute the super to myself. And the kids from the first relationship obviously challenged that, but they lost. And the reason they lost is because Mr. Munro, the lawyer, had written, I leave my super to the trustee of my estate. And it had to say that my legal personal representative, because that's the technical term you have to use under the SIS Act. And because he hadn't put legal personal representative, he'd put trustee of my estate, the binding death benefit nomination was invalid, and Mrs. Munro was within her rights as the trustee to distribute it to herself. So it's very important that we follow the technical requirements and the requirements of the deed, because every deed will have different things. So keep your deeds up to date. I know there are a couple of people in this room that I just updated their deed, so yours is up to date. But keep your deed up to date, consider the ramifications, make sure that they're technically valid. Consider whether you want to keep super out of the estate completely. If there's a risk of a challenge, like from a child that you lost contact with or something like that, if there's a risk of a challenge, you might want to keep as many assets out of the estate as possible. So it's important to tailor it to the individual circumstances. I won't go through Katz and Grossman, but the reason I brought that up in the slides was basically just to highlight the importance of looking at the control of a self-managed super fund. Because if you don't have a binding death benefit nomination in place, or for some reason it's technically invalid, then it will be up to the trustee how to distribute. And if you don't have the right succession mechanisms in place for the trustee, then and say one particular child becomes in control of the trustee, which is what happened in Katz and Grossman, then they can decide how to distribute. And as long as they distribute the super either to a spouse, a child, those people that were on the list, or the estate, then that's okay. So it's important to look at that and maybe consider putting a corporate trustee in place makes for a much easier succession plan. Just checking the time because I tend to go over. So we might jump. Does anyone have any questions about super at this stage? You can ask them later as well, but if you have any at the moment, feel free to pipe up. So let's just quickly look at trusts. So a lot of people will have a family trust as part of their structure, and it's important to remember that any assets that are in that trust will stay in that trust if something happens, if you die. So we need to make sure that the succession of control of that trust aligns with what we're trying to achieve under our wills. So if we're wanting to leave things to our assets to our spouse and then to our children, we need to make sure our spouse and then our children get in control of that trust and can make the decisions about it. Trusts can be a bit problematic because it's in one structure, so they're not easily divisible and they're discretionary. It's up to the trustee as to how income is distributed, as to how capital is distributed. So you can't bind the trustee to distributing equally between your children. And there are a lot of recent cases on that. So we need to look at the succession of control. That might be through your will, by appointing a new appointor. So your appointor gets to choose who the trustee is. They can take out the current trustee and put a new one in, so they can hire and fire them. So in a way, they're the ultimate controller of the trust. And then we also look at the trustee level. So if it's a company trustee, who owns the shares in that trustee company? I would say maybe a testamentary trust, so then it stays in the sort of family bloodline. So who is in control of the trustee? Who is in control of the appointor? But also look at the financials. Like we'll often get Shane to send through the financial statements for the trust so that we can see if there are any big loan accounts there that we need to take into consideration. Because if there's an individual that's owed a whole lot of money, so unpaid present entitlements from the trust, that's an asset of their individual estate. That would form part of their estate and be governed by their will. That might then require the trust to have to sell assets in order to satisfy those unpaid present entitlements. Or there might need to be some sort of forgiveness, and that could have other taxation implications. So it's important to think through all of those different aspects. One thing we can't do, which we wish we could still do, is split trusts. So you can't just say, okay, well, I'm going to leave half of it over here to this child and half of it over here to this child and just divide it up into two separate trusts. If we do that, that will trigger capital gains tax in relation to those assets, and changing the beneficiaries of the trust could resettle it. So we need to think through those scenarios. Now we get on to the fun topic. So this is all about testamentary trusts. We've talked about what's part of your estate. So jointly owned assets will go to the survivor. Superannuation only forms part of your estate if you leave it to your estate. Assets in the family trust or companies, they'll stay in those structures after you die. So we're talking about any personally owned property, personal shares. They could even just be nominal shares though in a trustee company, and then it becomes an issue of control. So we still want to consider them. Cash in bank accounts, any assets in your own personal name. A standard will is better than no will at all. So simple will, appointing an executor, leaving your estate where you want it to go. And there is a place for simple wills, depending on how the value of your assets and depending on who you're going to leave them to. So if you're leaving all your assets to charity, for example, there's not really any point having, unless you're setting up a charitable trust or something, not really much point having a complicated will in place. You could just divide your estate amongst the various charities. So you leave your estate, gets to the right people, simple, doesn't cost too much to put in place. But there are other ways of doing it which can increase the effectiveness of our estate plan and the effectiveness of our will. So that's where testamentary trusts come in. So essentially a testamentary trust is a trust like a family trust, quite like a family trust in most cases in terms of the sorts of powers that the trustee has. But it creates a trust under the terms of your will, doesn't come into place now. So you do your will and it has a testamentary trust in it. That trust isn't in existence now. You don't have a tax file number for it. You don't do financial statements for it. It only comes into play after you've died as part of the estate administration process, so applying for probate and then administering the estate. It is then established as part of that process. Shane would apply for a tax file number and an ABN. We do various resolutions to create the trust, and then from that point on, it's managed like any other trust. There's a trustee that's appointed to make the day-to-day decisions about the trust, and they hold the assets in it on behalf of a range of beneficiaries. So that might be even themselves, but it could be lineal descendants, so children, grandchildren, etc. It could be a broader class of relatives, could be other entities that the primary people are associated with, or it could be charities. So you can have a very broad class of beneficiaries, or you can narrow it down to a much smaller class, like have a lineal descendants trust, for example, or a bloodline trust. The benefits of having that trust structure created under your will are protective and also tax effective. So from a tax point of view, and this is often a big driver for people in establishing testamentary trusts, you can split income amongst a range of beneficiaries, like you can with the family trust. But the important difference between a family trust and a testamentary trust is that the income that's created from whatever investments you've made within the trust is accepted trust income. It can be distributed to minors, so children under the age of 18, and they're treated like adults for tax purposes. So they can receive up to the tax-free threshold tax-free. So let's say $20,000 tax-free, and then they pay normal adult marginal tax rates on their distributions, their income after that. So it can be a very effective way of managing an inheritance, especially say for adult children. So if you create a testamentary trust for your adult children, then they can use that inheritance and the income that they generate from it and distribute it to, say, their children, even if they don't have them yet, their future children and so forth. Or they could distribute to another family trust or a company. So there are lots of options around it. So essentially splitting income amongst a range of beneficiaries. There were a few, and people sort of went, oh no, testamentary trusts, that they don't apply anymore, because there were some restrictions put in place essentially to the definition of accepted trust income a few years ago. But all that really did was just say that the assets that go into the testamentary trust have to come from someone's death under their will. You can't add other assets into it and then have them treated in the same way. You can't then have the income that's generated from those later gifts into the testamentary trust as accepted trust income. Because what people used to do was they'd set up a testamentary trust under their will, and it might have a nominal amount go into it. And then the trust, they'd either put other money into it, the beneficiaries would put other money into it, or the trust would even borrow money. And so there'd be this influx of funds that they'd then invest, income generated from it, they'd then distribute to young kids, and everyone was happy. So they closed off that loophole. Our testamentary trust wills always provided that it was just the assets from the estate in any event, because that was always a risk, but they just formalised that. In terms of other taxes, in the same way that death doesn't trigger a capital gain, or doesn't trigger capital gains tax. So essentially when someone dies, you inherit the deceased cost base, unless it's the main residence, and then it will be the value at the date of death or a pre-CGT asset. But you essentially inherit their cost base, so you don't pay any capital gains tax or anything when you receive an inheritance. It's only if you then later go and sell that asset that it will trigger a capital gain, if there is one. And when it is triggered, it'll be the cost base that the original deceased person had. So even if it's gone through a few generations, like you might have a holiday house, say, that's gone from grandma to that person to that, and go through a few generations, the capital gain on that will just roll over. But then eventually when someone sells it, that's when it will trigger the capital gain, and it'll go back to the original cost base.
So you've got to be very careful on that because that is one of the hidden taxes
Mm.
with getting assets transferred to you under an estate.
Yes.
Yeah.
Yeah. So, but testamentary trusts still preserve that rollover relief. So if an asset goes from the deceased to the executor to the testamentary trust and then to a beneficiary of that testamentary trust as an in specie distribution, so to the beneficiary, that capital gains tax relief or rollover is preserved until that ultimate beneficiary then sells it. So that's just an illustration of what I was talking about. Yes, Sandra.
If the ultimate beneficiary sells the primary residence, do they have to pay capital gains on it? No.
If they've kept it for the main residence exemptions preserved for sort of 2 years, three years. But so if they've kept it longer than that, then it will, but the cost base will be the value at the date of death. So that's just an illustration of how you can distribute income amongst a range of beneficiaries and minimise the tax. So instead of Laura, who's my daughter, paying tax on that additional $60,000 going to her own other taxable income and whatever taxable marginal tax rate she's on, paying tax at that rate, she could distribute it to her 3 children of whatever age, and they would basically receive that $20,000 tax-free if they didn't have other income. They'd be assessed at their own marginal tax rate. So the other benefits, and I'll just do this quickly so I can give you a couple of examples of tailoring the testamentary trust to suit particular circumstances. The other main benefits of a testamentary trust are the protective aspects. So in terms of creditors or a trustee in bankruptcy, so if you've got a beneficiary that is financially vulnerable or is in a really high risk occupation or runs their own business and it's a bit risky, the assets that go into the testamentary trust, so long as they're not silly enough to distribute to themselves or and have it flow through to a trustee in bankruptcy, those assets are protected against a trustee in bankruptcy or creditors. So pretty much bubble wrapped. And another concern of a lot of parents is with adult children is, well, if I leave my hard-earned wealth to my adult child and their marriage breaks down or their relationship breaks down, I don't want everything I've worked so hard for to be split 50-50 between my child and their ex-spouse. So if the assets have gone into a testamentary trust, and there are ways of structuring it to be more protective than others, but assets that go into a testamentary trust are far more protected from a family law point of view than if a beneficiary received that inheritance outright. So the family court tends to either ignore the assets altogether, and that's a question of, well, who's in control, who makes the decisions. So you can structure it in a more protective way. So they'll either ignore the assets in the testamentary trust completely, or they might say, okay, let's say Oliver. So they might say, Oliver, you potentially are going to get a benefit from this testamentary trust. So we'll treat that as a financial resource that you have access to. So when we're deciding how to split up the assets between you, Oliver, and your ex-partner, we won't take those assets into consideration, but we might give your ex-partner a higher proportion of your assets, of your joint assets, because you've got other financial resources to rely upon. So they might consider it a financial resource for the actual person, for say your actual child, but they won't treat those assets as part of the marital pool of assets that are then divided up between the parties, which makes a big difference. So they are far more protected within that testamentary trust structure, and that's a concern of a lot of parents. So I'll just go through a couple of scenarios to illustrate how we can tailor the testamentary trust for your particular circumstances. So there are my beautiful children. They were a lot younger then. They're a lot older now. So they're 21 19, 17 and 15. So that's Laura, Oliver, Claire and Henry. And the little diagram on that side, it's in age order, but also height order. So, so the oldest is the shortest and the youngest is the tallest. So they're my 4 children. So in deciding how to structure the testamentary trust for my children, there are lots of things to take into account. One of the key ones is, do we have one testamentary trust for all 4 of them, or do I create separate trusts for each of them, one for each of them? So the sorts of considerations in that are how old they are, what value the assets that are going into the testamentary trust has. Do we need to try and minimise the administration costs by just having one? Or are we treating, am I very wealthy, which I'm not, but are we treating it as, you know, a family legacy situation where we want that wealth to be passed on for generations and to stay part of a family wealth that we want people, generations, to have custodianship of. So if those sorts of factors are important, then we might choose just to have one trust. But if you've got adult independent children, I'd say 9 times out of 10 you would have a separate trust for each of them, because you don't want to unnecessarily create conflict between them. You don't want them it could operate for up to 80 years like a family trust. So you don't want them for generations to come, like when their children are in control of the trust, to have to be working all together, getting a consensus on decisions, unless you're going to have it separately managed. So 9 times out of 10, I would say adult independent children, you'd have a separate trust for each of them, or even when they're on the cusp of adulthood, you know, create a separate trust so that they, when they take control of the trust, have some autonomy over the decision making. They have control of their own destiny and their own inheritance. They might be at different stages of life doing different things. The other reason you would have multiple trusts is if you're creating different types of trusts. You might need to create a trust for a particular child who is vulnerable or has a disability or needs to have a more protective trust set up where the capital is reserved. Or you might want a fully discretionary trust for other beneficiaries. You also might have an overseas beneficiary, so someone that's living overseas, and so you want a different type of trust for them, or you want different assets to go into it. So you want to create an Australian resident trust, but you only want certain assets to go into that trust because you don't want to trigger other types of capital gains if you transfer shares or something like that. So for me, for example, I would say right now at this point, I would still have one trust for myself and my 4 children, or not for myself when I die, for my 4 children, because I've still got kids at school. So I want that trust to be able to be used for them. And then, you know, at the end of it, I don't mind if it's just distributed out at a particular point. Down the track, though, I would probably create separate trusts for each of them so that they had control of their own inheritance and they could benefit themselves and their families going forward. So that's a common question we get. The other one is who should be in control of it. So if you're just setting up one trust for your surviving spouse and children, you'd probably have your surviving spouse in control of it. But if you're setting testamentary trusts up for children, are they capable of taking on that role on their own? Do they need a professional advisor or someone to hold their hand for a while or to show them the ropes? Or do they need another relative or trusted friend to be involved? So you could either appoint, you know, obviously relatives, friends, professional advisors. You know, Peter's appointed to a lot of estates, as is Shane. Yeah, and it's important to have that trusted relationship. You can also provide instructions which are not binding, but wishes essentially in a memo of directions as to how you would like them to act. So, for example, you know, don't unnecessarily get involved in decision making if you don't have to. You know, I want you there more as a circuit breaker than to be interfering in the decisions of the kids. Or, you know, I want you to make sure the trust is used for these purposes or to finance or fund these sorts of ventures. So you can provide a lot of detail in the memo of directions, which we also produce as part of our estate plans to sit alongside the will. But if you are going to appoint, say, a professional advisor, and, you know, like Peter or Shane or myself, it is important to think of, well, what if they can't act in that role? You know, none of us, we're not going to be around forever. Or what if something happens to one of us? So you've got to think of a succession plan for your own succession plan. So either have a backup person like from the firm appointed to that role, or if that person can't act, then put a substitute in or dissolve that position. So just make sure that that person has the right succession plan. You know, that Shane has put in his will. Well, if I'm executor of any, or if I'm trustee of any person's trust, then I appoint XYZ. Because if you leave it up to the default succession provisions, that will most likely be his legal personal representative. There's always default provisions in a testamentary trust, and so that the trust never fails. It's always got someone to act for it. And it will sometimes be the legal personal representative of the trustee in that situation, and that would be Andrea. So if you're happy with Andrea being trustee, she might not be happy about it, taking on 30 different trust positions.
Professional advisor, let's say it is Shane and your job title is what here, CEO?
Managing Director.
Yeah. Could it be that the succession plan is that nominated job title, that in the event that people come and go from the company, that you say whoever the managing director of that company is, that's who I want to be doing the job? And
that's one of the things that we ask you, like, is it the position that you want? You know, and obviously you want that person in that position at the moment. That's your first choice. But if that person's not around, do you want whoever the replacement person is? Or is it actually a personal appointment, which requires a bit more thought as to what the succession plan would be? So that's about control. But then we've also got to think about what goes into the testamentary trust. And the main one I want to look at here is, we've sort of talked about super and that going into the trust, is if the main residence or other property is transferred in specie, so in the state that it's in, from the estate into the testamentary trust. And in particular, say the main residence. So the family home goes into a testamentary trust for, say, the surviving spouse and the children. And that might be from an asset protection point of view. Because, you know, say you've got husband and wife, and I'll make all the assets in the husband's name because the wife has a very important job. And she's running her own business, trying to protect the assets of the family. So all the assets are in the husband's name, so that the wife, if something goes pear-shaped with her business, those personal assets aren't subject to, you know, creditors or a trustee in bankruptcy getting their hands on them. So they've structured, husband and wife have structured their personal property ownership so that the assets are in the name of the low-risk spouse. But then what happens if that low-risk spouse, the husband, dies? And the husband always dies in my scenarios. So the husband dies. And so if the husband dies, you've done this very fancy structure so that all the assets are in the husband's name. Husband dies unexpectedly, all the assets end up in the wife's name. So it's just defeated the purpose, really. So in that scenario, you might create a testamentary trust that can receive all the assets of the husband rather than in the wife's name personally, so that she can then manage them for herself and their children and, you know, distribute to other entities. And it's in that protected environment, in the bubble wrap, like we talked about before.
Does the testamentary trust establish after?
Yes. It's only after you die. It's in your will. So it makes your will a 36-page will instead of a few-page will. So it's like having the trust deed in the will itself. So you might put the family home into the trust, but there are a few things to consider with doing that. In that, you'll still have the no stamp duty through the transfer. The property will be valued at the date of death, and that will be the value for capital gains tax purposes. You might be able to, if you've got a carefully crafted right of residence in the will, you might be able to preserve the main residence exemption for capital gains tax, but you have to craft it really specifically, and there are some sort of tax rulings that have ruled against those clauses. So you might be up for capital gains tax if you ever then sell it, because it won't be considered your main residence. And land tax is a killer at the moment. So, and it'll be worse this year when the assessments come out, because all the thresholds have gone down. And not only that, if your family home is in a trust, in a testamentary trust, you not only will have land tax, you'll have trust surcharge land tax, unless you've got a clause in there that enables the primary beneficiary to have a right of residence in there, which we do in our wills. But you've got to weigh up those costs of holding the family home in a trust structure against the asset protection benefits you're getting from it. So you've got to weigh up that annual land tax. It's difficult to borrow against it as well when it's in a testamentary trust as opposed to in your own personal name. So you've got to weigh up those different factors. It is possible to then transfer the property out of the trust at some point. So that might be an option. Or we also often will build in, if that's a possibility, because you might set this will up with this testamentary trust in place now while you're still running your business. 10 years' time or 15 years' time, you might have sold the business. Those risks might not be there anymore, and you'd rather just have the property come into your own personal name. So we normally have an option in there where you can avoid the trust or distribute a particular asset directly to a beneficiary as well. So that was the reason for this visual, that with our testamentary trust structures and what assets go into it, we try to keep it as flexible as possible, in that get the assets into the estate. The key is appoint the right people to make the decisions. So put the right people in control to decide what assets are distributed to this trust, what assets are distributed to that. You can provide wishes around that in your memo of directions, but leave it flexible so the best decision can be made at the time, rather than being too prescriptive about it, unless there's a particular asset that you want to go to a particular beneficiary for some reason. So say, for example, that they live in that property. One last thing I just added on just a little while ago when I was finalising these slides is about holiday houses, because a lot of people will say, oh, and we've got a number of wills set up in this way, and I've been thinking recently, oh, that it's really a cause for review, because a lot of people will say, I really want the holiday house at Sorrento or Rye to stay in the family. I want it to stay in the family for my kids, grandkids to use. So one way to do that is to put that holiday home into a testamentary trust after both people have died. So it can then benefit the children, the grandchildren, lineal descendants, and it can stay there forever and a day. And if it's going to be held long term, the capital gains tax consequences aren't ever going to be realised. So, that might not be an issue. But vacant residential land tax will be an issue, because from the 1st of January 2025, all residential land in Victoria will be subject to vacant residential land tax, rather than just the particular councils that they've nominated at the moment. The rate at the moment is 1%, not of the site value that you pay your land tax on, of the capital improved value of the property, which is significantly more than the site value. So it's 1% of that a year. And once the new provisions come in on the 1st of January, not only that, but it's going to go up 1%. So it's going to go, if you've got your property vacant for 2 years, it'll be 2%. 3 years, 3%. I think it stops there, but still 3% of the capital improved value could be significant if you've got a multi-million-dollar Sorrento holiday home. So, and the catch is there is an exemption for holiday homes, but the exemption only, so if your property is vacant for 6 months, that's when vacant residential land tax applies, 6 months in the year. It can be over different periods. If the holiday home exemption applies, you only need to use it for 1 month. So, and you or a relative use it for 1 month or 28 days, I think it might be. But that holiday home exemption only applies if the individual owns it, or if it's held on a bare trust, which hardly any holiday homes would be. It doesn't apply if your holiday home is in a family trust or your testamentary trust. So that is something that should start factoring into your decision making in relation to those sorts of things.
Are these charges the one that our esteemed government have deemed to be a temporary COVID repayment tax or something?
This isn't temporary.
Right.
The
so
land
so
tax.
That's another tax, the one that the extra
Yes.
flood that they're giving everybody.
That's
that
the.
for any second property, regardless of. This just sounds as though it's only if something's vacant, whereas the other.
This is additional. You'd still have your normal land tax on this.
Yeah, this is a
Define
separate tax.
vacant, I mean,
Vacant is if no one's in it for 6 months or more.
no one is like, if I've got
Living it.
electricity.
And they're the sorts of things they'll look at. Electricity usage, tolls down the freeway,
You actually have to physically.
You have to
provide, and you have to provide evidence. So, you know, electricity bills that showed that you were using electricity for that week. And now with the State Revenue Office in particular, there's a lot more sharing of information. So it's getting harder and harder for things to fly under the radar. We've got quite a few voluntary disclosures going on at the moment in relation to land tax for that very reason. It's because the penalties are far worse if you're caught via an investigation rather than just voluntarily disclosing. So I just added that on because vacant residential land taxes created I've had a lot of questions about it lately, and it's not something that previously has been thought about in the context of estate planning. We'll talk about land tax, but holiday homes, it's quite common for people to want holiday homes preserved for generations. So it would be quite common for them to want it to go into a testamentary trust, but it's something to consider that there'd be this extra tax on it each year.
So just a quick one. So the executor deems the testamentary trust isn't viable.
Whoops.
But the will states that a testamentary trust should be established. Can the executor unwind it?
Yeah, so you can, well, it depends how the will is structured, but with our wills, you can. So with the consent of the beneficiary, you could leave assets directly to the beneficiary, or you could, before it's even begun, you could distribute out the estate in a particular way. So we have those mechanisms. We have the default position that the testamentary trust has set up, but then have options in there for, if it's not going to work for them. And it might not work if there's not enough capital to go into it, or if the annual administration cost, which is basically accounting fees really, to just, do the financial statements and so forth, if they outweigh the benefits, then you can wind it up. You can also wind it up at any stage throughout its life. It can operate for up to 80 years, but you can wind it up at any point.
And where the husband died, and when you do a testamentary trust with the risk-taking wife,
yes,
who is the trustee of that trust? The risk-taking wife, the trustee of it, or
whoever was nominated under the will, but she would probably be the trustee to start with. It's very much like a family trust deed, the terms and provisions of the trust. So there is the mechanism for the trustee to appoint a different trustee. So, she might incorporate a company and put a company in control, or she might, get someone else to act with her to so that she's not the sole person in control. So
that risk isn't brought.
Yeah, exactly. So, and that can be done at any stage like any other trust. And that doesn't trigger anything. Changing a trustee doesn't trigger a resettlement of the trust or capital gains tax or anything. So that's just changing control.
So what happens at the end of the 80 years?
Yeah. Well, actually nothing. In that it's only technically under the deed the trust is at an end, but nothing actually happens until you actually do something.
Like
so
in the case of the holiday house, which was, wanted to last forever
Yeah.
as part of the family
Yeah.
estate, at the end of 80 years,
Yeah.
then
That's
the
when,
gains trigger.
that is when the capital gains tax would trigger. So it would, but it could be dealt with, you see, it can be dealt with within the trust structure, in that the capital gain could be streamed amongst a range of beneficiaries to the lower tax paying beneficiaries.
You can't renew the trust.
Well, you can create a new trust, you can roll it over into a new trust, but if you extend it beyond the maximum life of a trust, which in Victoria is 80 years, then it will trigger, it's a resettlement, it's a new trust. So if there are capital gains tax consequences, that's when they would come into play. But, I think if you've structured yourself, if you've structured yourself for the benefit of your relatives, and that's all done well for them for 80 years, then the great-great-great-grandchildren can pay the tax.
I haven't had a trust get close to 80 years yet. About 55 years is the closest one I've got. So
It's just get too hard. I've got a mate who's got a beach house that the parents have left. There's two brothers, and they're saying, "Oh, we want our kids to have it," and they go, "But it's not really important to them. It was important to us." And after all, they just go, "Screw it."
Yeah.
And those discussions are important to have, and that is something that we do quite a bit of, having those discussions with the family while you're still alive, so you can explain, so they don't get a huge shock and think, "Oh my God, what is this complicated thing that mum and dad have done?" But with testamentary trusts and everything else. But it's good to have those discussions, and I still think you should do what you want to do. But then, and we can certainly assist with then explaining it in a way that beneficiaries, your children, understand, and so they can make it work for them. I won't go through the super because we've sort of covered that. The main thing with super is if it comes into the estate, you'll pay superannuation death benefits tax regardless if there are, adult children that are benefiting from that. If it's going into a trust with a spouse and, say, minor children, then it would be received tax-free. We have a special provision in our wills that quarantines the super for any tax dependents, if there are tax dependents, so that it can be received by the trust tax-free, because otherwise the tax office will say, well, if you've got some beneficiaries of your testamentary trust that can receive the super tax-free, and you've got other beneficiaries that will pay superannuation death benefits tax, then we'll just charge superannuation death benefits tax on the whole lot. So to avoid that situation, we create a sub-trust for the superannuation proceeds to quarantine it for anyone that can receive it tax-free. If there isn't a dependent that qualifies to receive it tax-free, then it doesn't matter. It'll just go into the testamentary trust.
And is that part of the testamentary trust, did you say? That's written
yes, we have that clause in as a standard thing, that if there is a dependent, because you might not know it at the time when you do the will. So, for example, I've got an estate at the moment where there is one adult child who was financially dependent on her mum. The estate is being split equally, but she can receive in testamentary trust, she can receive the super tax-free, because at the time of death, she was financially dependent on her mum. She was living with her, mum was paying all the expenses. She was suffering from a mental illness, so she can receive the superannuation tax-free. Overall, they're going to receive the estate equally, but her 50% will partly come from the superannuation, because that can be received tax-free, which benefits everybody because less tax is being paid by the estate. So that's why I say, and why I had the rule of thumb, well, it was a rule of thumb and forefinger, that it's good to keep it flexible, so that you can distribute assets in a particular way at the time, depending on what suits. A lot of people will just say, look, we just want it to be simple. We're just going to sell everything, get the estate to deal with the capital gains tax. We might spread it out over a couple of years. We had that one, Peter, recently with the properties, where we sold some properties. Some properties were sold in one tax year, some properties in the next tax year, so that then any capital gains tax could be dealt with in a couple of separate years. So there are strategies that you can employ to minimise that, but some people will just say, let's sort of liquidate it put cash into the testamentary trust, let them do what they want with it. But then if there are particular assets you want to preserve as those assets, then there's also that flexibility to do that. The last thing I'll mention, and then I'm happy to, we've discussed foreign beneficiaries, to take any questions at all, is just the bank of mum and dad, because, you know, I know that parents have to lend kids money to buy houses and all sorts of things nowadays because it's so difficult to do on your own. So one thing I would say if you're doing that is put a loan agreement in place in relation to it, because there is a presumption that if you give money to your child to then go and buy a house, if it was anyone else other than your child, then you contributing to the purchase of that property would almost be like they were holding part of that property on trust for you because you've funded it. But when it's a parent-child relationship, that resulting trust presumption is rebutted. And so the presumption is that that's a gift to the child to buy the house. You don't have any interest in the house by doing that. So the way of getting around that is to make it not a gift, to make it a loan. But there are certain requirements for making that loan enforceable. There are timeframes. You don't want it to become stale. You want it to be enforceable. It is good if you can have some sort of repayment of some kind. You don't have to, but it just adds to the enforceability of it. But in the context of testamentary trust, which is what we're talking about, that loan to the child is still an asset of yours because you've lent the money. You're the lender. You're like the bank in that situation. The child owes you the money back. So if you die, it's still an asset of your estate. So in your inventory of assets and liabilities, when probate's applied for, it'll say loan to child, $200,000, say. And that's an asset. So, you know, it'd be pretty rough on the child if they then had to somehow find that $200,000 to pay into the estate. But if you've structured it in a way where assets can be appropriated to various trusts, then the estate as lender can say, okay, well, I'm giving the benefit of this loan, this $200,000 loan to that child. So then that child owes the $200,000 to their own trust. And the benefit of that is it preserves the protective nature of having a loan, because if anything has gone pear-shaped in the child's life, they owe this money back to either you or to the estate or to the trust. But it also gives them a mechanism as they go through life and create more wealth for themselves, provides a mechanism for them to say, actually, I've got some spare cash. I am now going to pay back that $200,000 loan to my trust. And then that $200,000 is in the trust structure, that lovely bubble-wrapped trust structure, that tax-effective structure. And that trust can go and invest the $200,000 and create income and distribute the income to the children. So it's a way of getting money back into that trust structure if you have given or lent money to children during your lifetime.
So if it was considered a loan to the child, but they didn't document it properly, and mum and dad died, it would then be considered a gift. And if there was multiple children, that they didn't care so much that mum and dad had loaned them $200,000, but then the minute they died and it became a gift of $200,000, the other 3 or 4 kids go, "Where's my $200,000?"
Well, you'd be relying on trust and them and everyone to respect the verbal agreement, because of course you can do things verbally. You can lend money to someone verbally. I can give Shane $10 and say, you have to give it back to me tomorrow, and he says, yes, I'll give it back to you tomorrow. Well, we've still got a contract. We've just got a verbal one that I've given you 10, you'll give me back $10 tomorrow. There's enough certainty in that. So you can still have a verbal agreement, but you're relying on, if there's no evidence of it, other than the money going out of a bank account, there's no evidence that it was a loan as opposed to a gift. You're relying on people to do the right thing, really. So, and respect that that's a loan without it being documented. It just becomes more problematic and easier to avoid, less likely it would be enforceable. So if someone said, no, so the child that had received the money, for example, if they said, no, it wasn't a loan, it was always meant to be a gift, how do you enforce that loan when you don't have any terms around it? There's no repayment terms, there's no interest, there's nothing to say it was a loan. So it would be very difficult to enforce. So, and it can be a simple loan agreement, and we'll often do that as part of the whole estate planning process. So, key points, and then I'll throw it open for questions. So, be courageous and open in sharing things with us. You know, like we speak to so many different people all the time, and the great thing about my job and the thing I love the most and the reason why I do estate planning is because I love learning about people's lives. I love connecting with people and learning about their families and learning about what's important to them, because everybody's values are different and everybody has different objectives with their estate planning. And even though on paper it might look really great to have testamentary trusts that do this, and I'll say, oh, there's all these benefits, tax benefits, blah, 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 that might not be your priority. Your priority might be making sure that that particular person is looked after in a particular way. So it's really important to be open with us, share with us about your families, let us get to know you, and we will look after you, because that's part of our values, being courageous custodians of our community. So be courageous and open with us. Consider testamentary trusts as part of your estate plan. It won't be applicable to everybody, but it's worth considering and having a conversation with us, because it may well be something that is of value, not for you because you won't be here, but for your beneficiaries. Remember that it's more than just a will. We need to consider those other entities, trusts, companies and so forth, and superannuation. So we need to look at how you're structured in order to advise you properly. Get advice on the tax implications, but as I said before, that doesn't have to be the driver. It's not always about minimising tax. And, you know, and that's something that Aintree stands for, that it's not just about tax. It's far from it. In fact, that's probably the least important thing in the whole process. Plan for now, but as well as the end in mind. So I always say you can update these things. You know, it's only if something happens to you in the meantime where you don't have the capacity to update your will that you can't update it. Otherwise, make it fit your current circumstances, but also so that it would still go 90% of the way there if you didn't get around to updating it for the next 20 years. So just we've got to balance those different objectives and look to the future as much as we can as well. Review it regularly, because things will change. You know, things will change in your family dynamic. Things will change in your asset position. Things will change in with your priorities. We normally say if there isn't a trigger event, look at it every 3 to 5 years. Look at your memo of directions, which basically sets out your wishes every year, and review it regularly. So look at it 3 to 5 yearly, but if something happens in the meantime, anything happens to any one of the beneficiaries or the executors, or something significant changes with your financial position, then that would be a reason to update it even earlier. And we can assist you with that, and that give you the tools to be able to do that. So we've got a platform called Aintree Custodian that is just recently been established. So anyone that does their estate planning with us will get an invitation to sign up to that. And it's essentially a platform that enables you to store all your important documents, provide instructions. You can keep passwords on there. You can leave instructions for your loved ones if something happens to you. So if you die, then that would be a trigger for this and this to happen, or this person to be notified. And you can keep things like your memo of directions that set out your wishes, those more personal things that aren't part of the legal structure. You can keep that there and update it whenever you want to. We don't have access to your documents unless you tell us to, like whatever you put on there, other than the estate planning documents that we upload for you. So it's a completely personal thing that you can tailor for yourself. It's optional, it's free, but it's just part of us being able to make your estate plan work for you in the best way and add value to your lives. Did I cover what it does, Katie?
Yeah.
Because Katie and Tully are in charge of that. Any questions? Happy for curly ones? Yes, Chelsea.
Would you recommend, and this is sort of leading on to the Aintree custodian section,
things like passwords or email account and important stuff like that that people might need access to? Should that be part of it?
Good question, because I just was copied in on an email this afternoon that Katie responded to from a client with that very question. And yes, it is a platform that you can hold your passwords on. I know there's a lot of password platforms out there or security boxes out there, but it is a, what do they say, military grade security platform.
And there's certain mechanisms in place for when you do die, that there's steps that are taken that then obviously your death is proven, and then certain information is released to the instructions that you created during your lifetime.
So yeah, it's not just that someone will say, oh, that person's died, can I have all their passwords? Obviously there are death certificates and things that need to be shown, so it is a process. And you can also put your own controls on that as well. So, I don't want this released to this person, or I do want this released to that person. Any other questions? Yes.
Just taking that one a little bit further, how are you dealing with people's digital footprint?
Yeah, and that's been something that the law, especially in this area, hasn't kept up with over the years. So up until we introduced this platform, it was very much, well, you could set it out, either use a password, program, separate program, but then how do you give access to your executor to that program? It's really tricky because, of course, as soon as you tell the bank or anyone that someone's died, they'll freeze all the accounts. And so it is a juggle, because you want people to record the information to make it easy for their executor, but you don't want it to get into the wrong hands. Say you're broken into and someone just got a whole list of your passwords, or your computer was stolen. So in the past, we've said you can put it in a memo of directions, and we can store it with our deeds, with your will, and other important documents, and just update it when you can. But this is a much more secure platform for that digital information. A lot of platforms now, so Facebook or Instagram, they've got their better policies in place. It's been a long time coming, but you can appoint digital executors, I think sometimes they call them, or you can appoint specific people to be able to deal with your account. But because all of those things are under license, it's how much do you actually own that's in there? So it is, and in our will it does deal with digital assets as part of your personal property, and in our memo of directions it has various options where you can direct your executor to do things like, I want my email accounts deleted, or I want this memorialized, or I want the information saved here, or so you can give directions around that. But the law, I think, is still catching up a little bit, particularly in relation to wills and estates. Let's face it, everything can be signed electronically except wills, powers of attorney. All of those documents have to still be signed. There is a mechanism for it to be electronic, but it's very convoluted, and there have been recent cases where COVID wills haven't held up, even though they've been signed electronically under those provisions. So, you really still need to do it in wet ink. So that platform would certainly provide an answer to those sorts of issues, and previously we've had to do it, just by keeping it safe. Yes, see.
How you said you would have a trust for each of your 4 kids?
Mm-hmm.
If you have your main residence and you want to keep it to the kids, how do you put it into 4 trusts?
They can own it as tenants in common. So the 4 trusts can own it as tenants in common. The things you would want to discuss or think through about that is, well, are they then equally going to be paying for all the maintenance and the rates and the land tax and everything else on the property, which they would if they were owning it equally. So you would want to think through whether that was the best option. I would normally allow that to happen by having the will flexible enough for the home to be retained and for 1, 2, 3 or 4 of the trust to own it. But I probably wouldn't prescribe it in case it didn't actually suit the kids at the time. I just allow it and maybe even put wishes in around it, unless of course it's a family home, like Generations family home or something like that. You could also create, if you've got some kids that are still living at home, for example, you could create a right of residence or something under the will for a period, you know, for a couple of years while they, or until they're adults, or their lifetime if you really want to. But there are other options to enable people to still live there, but not have the asset necessarily retained forever.
Is it still 2 years? Is it 2 years? You've got to sell the residence.
3.
3 years.
3 years.
Yeah.
I think it's right. I'll better check that actually.
Yeah. Because I said 2 before and then you said 3.
Yeah.
So I thought, oh,
What was it in relation to?
Principal
the main
residence,
residence.
transferring it, selling it.
I thought it was 2, but
But if I understood correctly, so if the property was pre-purchased, pre-capital gains tax, so pre-84,
yep.
does that then still remain capital gains tax free?
No, it would be from the date of death. It would be valued. Yeah. Yeah,
So
that would be the
original.
No, because if it was the main residence or it was pre-CGT, then it would just be at the date of death that it was then valued, and it would be from then on. It would be the capital gain from then on.
I take it back. It is 2 years. Sorry, my apologies. That's 2 years. Yes.
And can you transfer a family trust to a testamentary trust?
No, because that's gifted. Because you can only have assets that are part of the estate, and a family trust isn't part of the estate.
Oh.
So yeah, if there are loans, like say personal loans to the person, then they could be paid into the estate and into the testamentary trust. So unpaid present entitlements or something like that in the trust could then be paid back and paid into the estate. But the assets of the family trust will stay in the family trust and be dealt with. They can either just stay in there, or they can be sold or distributed out, but that will trigger capital gain. If there is a capital gain, there might not always be.
Always is.
Any other questions? I know I've bamboozled everybody with information.
Really good.
I talk a lot. So, well, thank you for coming.